Hi, I'm Urick Duggins, and I'm an attorney at Parmenter O'Toole. I specialize in estate planning, and the topic of this segment is going to be what constitutes an estate plan. And a lot of people say, well, I don't have a lot of assets. I don't think that I really need to have an estate plan. An estate plan is simply a plan for the distribution of your assets, either during your lifetime or at the time of death. And it also provides documents that will allow someone to make decisions for you in the event that you are unable to make them for yourself. So I thought today what we would do is walk through each of the documents that are involved with an estate plan. And we generally have a will, a trust, a healthcare power of attorney, and a financial power of attorney. So we'll start with the will. And the will gives you the ability to state to whom you'd like your assets to be distributed on your death. And in the event that you don't have a will, the laws of Michigan will distribute the assets pursuant to what the laws of Michigan deem appropriate. And they typically stay within your bloodline. But if you do not want, they're not going to make a gift to charity. They're not going to make a gift to a stepchild. They're going to give to your spouse if you have a spouse. And if you're in a second marriage situation where you have children from a previous relationship, there's some special rules. The spouse doesn't get 100%. Some is for your children. If you have no spouse but you have children, then your assets will be distributed to your children. If you have no spouse and no children, then your assets go to your parents. If you have no spouse, children, or parents, then they go to your siblings, and so on. If they don't find anyone that you're related to, then that is the situation when your assets revert to the state of Michigan. And oftentimes people are very nervous about that happening, and it's very rare that it happens, but it does happen in situations where no heir can be found. So that's what you can do with a will as far as the distribution of your assets. In addition, in the will, you get to appoint someone as a guardian for any minor children that you might have. And that's one of the main reasons that I see people for estate planning is they have minor children and they want to make sure that the proper person is appointed to act as guardian for those minor children if something should happen to them and their spouse. And so you can appoint anyone that you would like as long as they're over the age of 18, and you can have a backup to the guardian as well. The will also allows you to appoint someone as a personal representative. And a personal representative is, people often think of it as an executor, and that is the term that used to be used in Michigan. Now the term is personal representative. But it's the person who's in charge of wrapping up your estate after you pass. They're responsible for paying your creditors, identifying your assets, liquidating the assets, and then making distribution pursuant to the terms of the will. So those are the three main things that the will allows you to do. The will does not avoid probate, which is, I think, a misconception that a lot of people have. They think that if they have a will, that they don't have to go through that probate process. However, the will simply is just telling the probate court how you would like your assets to be distributed, who you would like as guardian, and who you would like as personal representative, so that the laws of Michigan don't determine, but you determine. If you are interested in avoiding probate, there's a number of ways that you can do that, but the most common way, and a way that most people feel is recommended, is to create a revocable trust. And sometimes it's referred to as a revocable living trust or an inter vivos trust, but they're all the same type of a trust. It's a trust that's created during your lifetime and that is revocable, which means that it can be revoked or it can be amended as long as you're competent. So, and by creating a trust, that in and of itself doesn't avoid probate. What avoids probate is actually transferring the assets to your trust. And so what that means is if you own a house and you own it individually as husband and wife, then you have to transfer that house to your trust, and then that is what will avoid probate. Joint ownership also avoids probate. So as I indicated, if you own that house jointly as husband and wife, it will pass to the surviving joint owner if something happens to one of you. But if something happens to both of you, then it will have to go through a probate proceeding to get transferred to your children. If you have it owned by your trust, however, it won't have to go through that probate proceeding. It will remain in your trust, and your trustee can distribute it to your children pursuant to the terms of the trust document. The trust also gives you the ability to prolong distribution of your assets after the time of death. And this is often common when we have minor children. People do not want them to receive their assets outright at age 18. If you just have a will, then at age 18, the assets are distributed to the children. Prior to reaching age 18 with just a will, the court will appoint someone to be a conservator for those assets. And having a conservator requires that the conservator file annual reports with the court stating how the assets have been invested and how they've been distributed over the year for the benefit of the child. But at age 18, then whatever assets are remaining would be distributed outright to the child. However, if you have a trust, you can pick whatever ages and distribution amounts that you would like. So you can say half at the age of 25 and the balance at the age of 30. You could say a third at the age of 30, a half the balance, which is another third at the age of 35, and the balance at 40. It's whatever it is that you think is appropriate for your children. Prior to reaching those ages, it doesn't mean that they can't receive a distribution from the trust. It's just not up to the child as to whether they receive a distribution. It's up to the trustee. So these are generally discretionary trusts, with the trustee having the discretion to make distributions before the child reaches the ages that you've put into the trust. And generally those distributions are for things like their health. So if they have health issues, the trustee could make a distribution. If they are going to college and they need their tuition to be paid, then that is something that the trustee could pay. Or for just their daily living needs. So if they need it for food, shelter, and clothing, certainly these are things that the trustee would be able to make payment for them prior to reaching the age that you allow them to have the outright distribution. So one reason to have a trust is to avoid probate. Another is to prolong the distribution of the assets until the beneficiaries reach a certain age. Another reason that people do trust is for estate tax planning purposes. And I'm not going to get into a detailed discussion of that in this segment, but you should know that if you have assets in excess of, right now, $5 million is what the estate tax law allows you to transfer estate tax free. If you have assets in excess of that amount, you really need to do some estate tax planning to make sure that you are taking advantage of the estate tax laws the best that you can. And so I'll just leave it at that. Know that you should get some planning if you're in a situation like that. There are other reasons that people create trusts. One is if you have special needs children, they can't receive a distribution from a trust without jeopardizing their governmental benefits that they may be receiving, like SSI and Medicaid. And so it's important that you coordinate a special needs trust with your estate plan documents so that that special needs beneficiary would be able to receive those benefits without jeopardizing their governmental benefits. Another reason, sometimes you'll hear of irrevocable trusts for Medicaid planning, and I do those as well, but that's a very specific type of trust that's only done in conjunction with Medicaid planning, and we don't do that as a general course in the process of estate planning. So those are the reasons that people generally do trusts, and that's one of the most common questions that I get is, do I need to have a trust or not? And it's really specific to every person's needs, and that's something that I'm happy to sit down and talk with you about as to whether or not that's something that you would need or not. We also make sure to do powers of attorney for people. There are two different kinds of powers of attorney. One is a financial power of attorney, and those can be effective when you sign them or upon disability. And if they're effective on disability, it requires that a doctor state that you're unable to make your own financial decisions before the agent that you appoint in the financial power of attorney would be able to make those on your behalf. If it's effective immediately, that means that when you sign the document, the person that you're appointing is able to make those decisions. And if you're unsure which is the best for you, again, that's something that I'm happy to talk to you about. You can appoint anyone that you'd like as your agent, and they have to be at least 18 years of age. You can appoint more than one person. You can say that they have to act jointly, or either one can act, whatever your preference. You can also name alternates, so you can have a first choice, a second choice, or a third choice, whatever works best for your situation. And again, I'm happy to talk to you if you are unsure as to who you would like to name in that position. The healthcare power of attorney is a similar concept to a financial power of attorney, but it's for your healthcare decisions. And you appoint in Michigan what's called a patient advocate to make your medical decisions for you if you're unable to make them yourself. The laws of Michigan require that 2 licensed physicians state that you're unable to act before your patient advocate can make the decisions on your behalf. Once they are able to make those decisions, though, they can make all of your medical decisions for you, including end-of-life decisions. And I think end-of-life decisions are the most common example of when the patient advocate acts. But again, you have to remember, especially if you have dementia or something, Parkinson's, they may have to make a number of decisions for you for a long period of time. The end-of-life decisions are often what people refer to as the living will provisions. Michigan doesn't have a separate living will, but in these healthcare powers of attorney, there are living will provisions that state what you would like to have happen in the event you're on life support. If you wanted a DNR, which is a do not resuscitate, that is something that I recommend that you do in conjunction with your physician. So the 4 documents, again, just to kind of summarize what make up an estate plan, are a will, a trust, which we don't always do a trust, but sometimes, and then a healthcare power of attorney and a financial power of attorney. The other point that I want to touch on, which is I think something that is often overlooked, and to me, one of the main reasons that an estate plan goes wrong, is that you need to make sure to coordinate your assets with what your estate plan documents state. And what I mean by that is if you have life insurance or retirement plan benefits, annuities, transfer on death accounts, any type of an asset in which you can name a beneficiary, it's very important that you coordinate your beneficiary designations with the terms of your estate plan. So that may mean that you name specific people as the beneficiary. It may mean that you name your trust as a beneficiary. It just depends on what your plan is. But we help you go through and coordinate those beneficiary designations and instruct you as to how they need to be completed in order to coordinate them with your estate plan documents. In addition, you need to look at the ownership of your other assets where you cannot name beneficiaries, and we talked a little bit about that when I talked about transferring assets to your trust. And so we would look at all of your deeds for your real estate. If you have stock in companies, we would look at that. If you have bonds, any type of asset that you would have, we would take a look at each one of those, and I would give you instructions as to how each one of those needs to be titled. Sometimes people already have existing documents, and I am happy to review those documents for you. People will say, well, how often should I look at my estate plan? And we generally send people letters every 3 years and ask that you review your estate plan documents. But depending on your situation, you may need to review them more often than that. And if you're questioning whether you should review them, I'm thinking you probably need to get them out and take a look at them and make sure that you look at your assets as well, make sure everything is up to date. But I am happy to look at your existing estate plan documents if you already have them and let you know whether or not I think any changes need to be made. If you'd like to schedule an appointment with me to discuss your estate plan, you can either give me a call directly at 231-722-5415, or you can contact my assistant Janet at 231-722-5417. We also have email addresses which are available on our website, and you can feel free to go ahead and email us as well. A lot of people are concerned about how much it costs to have an estate plan prepared, and I like to work on a fixed fee basis, so I will tell you when you come in to meet with me how much it's going to cost to have your documents prepared after we go through what your needs are and what your wishes are. And if you decide that you don't want to move forward for whatever reason, then there's not a cost for you to come in and meet with me to review your existing documents or for me to give you a consultation as to what I think you need to have. So if you have any other questions, feel free to give me a call. Otherwise, I thank you for watching this segment.